This is a lecture from Open Tuition. For the free lecture notes that go with this podcast, please visit opentuition.com.
We're on page 85, directors and the controls over directors. If you accept that directors are in a position of, effectively a position of power, they're able to do what directors do, and therefore they're in a rather more powerful position, for instance, than you. And they need some sort of control, because it's investors who invest in their company, and if they start dictating how their company shall operate, they have that control. There needs to be some restriction imposed on them. The statutory duties, statutory duties. Come on, statutory duties of directors. Act within their powers. Put happy and. It's no good writing happy and in the exam. You've got to be able to. It won't come probably. It won't come in your exam because it came up in the last exam, but it might just do. Happy and. Act within their powers. Perform with due skill, care and diligence. Yeah. P, what did my football team nearly achieve 2 years ago? Promote. Promote the success of the company in the eyes of all the different stakeholders. Happy. Independent judgment. They should bring to their office independence and objectivity, and they should work for the long-term benefit of the company. A, avoid conflicts of interest. Don't let themselves be put into a situation where they have conflicting interests. Don't compete with the company. Don't have shares in competition companies or competitor companies. N, no bribes, no benefits. No benefits. And D, disclosure. A disclosure of any interest that they may have in any transaction or contract into which their company is or is about to enter. Okay, page 85, control. Service contracts greater than 2 years require approval by members. There is a maximum period within company legislation that says you cannot have a service contract longer than 5 years. It can be a rolling contract, or you could have a 5-year which finishes then, and then another 5-year. But in order to give an element of continuity, you can create a new 5-year contract within the last 6 months of the previous 5-year contract. But that's tiny, don't get bogged down with that. Acquisition of non-cash assets need members' approval if they're greater than 10% of the company's assets. Do you know, I've just remembered something which I didn't tell you earlier about requiring a resolution on an agenda, but I will come back to it. Now I've remembered that I should have told you. I got distracted. But now I remember that I should have told you. I will tell you later on. There is a position where I can bring it in again. Okay? So, putting forward a resolution to remove a director. What if it's only a private company and there aren't 100 members? How can you have 100 members holding on average £100 worth of share capital? Well, then it should be 5% in number, or the holders of not less than 5% of the shares. Either 5% in number of the shareholders, or the holders of not less than 5% of the share capital. So if it's not a company with 100 members, then we still have this alternative, or the holders of not less than 5% of share capital, or not less than 5% in number. But I said I was going to tell you later, and I've just told you now, so I won't tell you again later. Acquisition of non-cash assets need members' approval if greater than 10% of the company's assets. But if it's less than 5,000, nobody cares. If it's more than 100,000, then everybody cares, even though it may be less than 10% of company assets. If it's more than 100,000, it has to get membership approval. No company may lend money, provide security, nor guarantee a loan to a director of itself, nor of its holding company, unless this is approved by members. Now, I've read that out for you. You read it for yourselves. Just read those 2 lines again. And make sure you fully understand what those 2 lines are saying. Is there anything vague? Is there any ambiguity? Is there any uncertainty about those two lines? Those two lines are very carefully written. A holding company is the parent company. So in a group situation, it's the one at the top. It's the parent of the subsidiaries. Okay? We've got a company here. Just imagine this. We've got a parent company, the holding company, and a subsidiary. And we have the directors of the parent company and we have the directors of the subsidiary company. And we'll just give them simple letters A, B, C and D, A, E, F and G. All right. Can company S lend money to B? Why not? Well, because the law says it can't. No company can lend money to a director of itself, A, E, F or G, nor can it lend money to a director of its parent company, A, B, C or D. So no, company S cannot lend money to B. Can company H lend money to F? Look at the law. No company can lend money to a director of itself, nor of its holding company. It doesn't say that a company can't lend money to a director of a subsidiary. So yes, H can lend money to F. Well, if H can lend money to F, can H lend money to A? If H lending money to F is okay, is it equally acceptable for H to lend money to A? No, because A is a director of the holding company, so it's lending money to a director of itself, so that would not be allowed. Can H lend money to Mrs. C? Can't lend money to C, because that's lending money to a director of itself. But can it lend money to Mrs. C? Yeah. Because Mrs. C is not a director. C is a director. But Mrs. No, not in the UK, even if we're still married. We're still separate people. Mrs. C is not a director of H, therefore H can lend Mrs. C money. Isn't the law wonderful? Can S, subsidiary, pay the school fees of child D? Child D isn't a director of H. It's not lending the money to D, it's paying an expense on behalf of child D. Why not? The law does not prevent it. Can H enter into a credit transaction on behalf of B? Can H enter into a credit transaction where H assumes the position of the one with the obligation? They are a creditor. So on behalf of B, H will stand in B's place and say, we will be the creditor. Can that happen? It's called a credit transaction, and in fact it can, because the law says we can't lend money, nor can we provide security, nor can we guarantee. But it doesn't say anything about credit transactions where the company will stand in the position of being the creditor. It doesn't say anything about that. Just continuing this for a moment, and I'll come back to this chart, but just continuing it, we have company T, where Mr. T is the only director. And we have a company U where Miss U is the only director. Can T lend money to Miss U? There is no connection. They're completely separate companies. They're not in the same group. Can Company T lend money to Miss U? Yeah, why not? Okay. Can Company U lend money to Mr. T? Absolutely, it's the same situation. Can you lend money to Mr. T and at the same time T lends money to Miss U? No. That is specifically not allowed. That's called a back-to-back transaction. This is simply an attempt to circumvent the principle of law that says companies shall not lend directors money. And that is a conscious effort to get round it. So that would not be acceptable. Individually, you can lend T money. Individually, T can lend you money, Miss U, but you can't have the combination where they're both lending to each other. That's not acceptable. That's against the law. What about this one? Can S lend £4,000 to G? Can the subsidiary company lend £4,000 to G, the director? Well, actually, yes, it can. The basic law says you can't lend money to a director of yourself, nor of your holding company, nor guarantee, nor provide security. But who the hell cares if it's less than £5,000? If it's less than 5,000, nobody cares. Can S lend £100,000 to F so that F is able to buy or improve her main or only residence? So can I lend £100,000 to Miss F in order that she can buy a house? Actually, you can. That's acceptable, so long as it's in the course of business, so long as this company makes the same offer available to all employees. But who's going to tell the employees? Who's going to tell them? Nobody, no. Can H advance £15,000 to A in order that A can meet his normal business expenses? Yeah, up to 20,000 you can do it without prior shareholder approval. So yeah, that's another one which is a little bit exceptional. Now, I'm just going to change this a little bit, only a tiny bit, and that is I'm going to tell you that there's a sub-subsidiary down here, and the sub-subsidiary is actually called SSPLC. It only has one. It only has two directors, X and Y. Now then, what about any of these transactions? Children, wife, husband, money being lent to meet legitimate, money being lent to buy houses. As soon as you get a PLC within the group, as soon as you get a public company within the group, the rules change. And the rule then becomes, no, you can't lend money to Mrs. C, because Mrs. C is a connected person. And so the law changes and says you can't lend money, nor provide security, nor guarantee, nor credits transact, nor quasi-lend, which is effectively a loan, but it's not a loan, neither to a director of yourself nor your holding company, nor any of their connected people. So the basic law, which is applicable to private and technically non-relevant companies, that piece of law, as I've shown you there on the screen, that piece of law is like trying to catch water in a bucket where there's no bottom in the bucket. It's just a stupid piece of legislation, although I can't say that because I'm not a person who's qualified to say what is stupid and not stupid in legislation. But this is, I mean, effective. The only thing I can't do is I can't lend money to a director. But I can lend it to a director's spouse or a director's child, and I can lend money in order that they can buy a house. So all sorts of things I can do if I'm not relevant. But as soon as you get a PLC within the group of companies, then all the companies become relevant companies. And for relevant companies, the law extends. You can't lend, guarantee, secure, quasi-lend, credit transact, neither to a director of yourself, nor of your parent company, nor to any of their connected people. Now, connected people is defined, and I doubt very much whether Mr. Kelly will ever ask what is meant by connected people. We're getting into fine detail now in the legislation relating to directors' loans, and I doubt very much that it would ever come up. So I'm not going to tell you, but effectively it's your husband or wife and your infant children. Your infant children. How old is an infant? How many? A couple of months. That's an infant, isn't it? What did you say? 16, no, a little bit more than that. 18 years. You were an infant. You used to be an infant until you were 21. But you're an infant now if you're, or you lose your infancy if you're above 18 or 18 and over. Okay. So I'm going to leave it at that. I'm not going to go into any greater detail than that. We've got here on page 85, no company may lend money, provide security, nor guarantee a loan to a director of itself nor of its holding company unless it's approved by members. But this, in the context of non-relevant companies, is the bottomless bucket. You're not going to catch any water. But as soon as you get to achieve relevant status, and there's a public company within the group, then it's very, very tight indeed. And there are the de minimis ones where you can lend 5,000 or up to 5,000, and you can still lend up to 100,000 if it's in the course of business, but otherwise no. Relevant companies can't quasi-lend unless it's 5. They can't approve credit transactions unless it's approved by direct members. Any company can lend up to 5. Loans by money-lending companies are allowed for the purchase or improvement of your main or only residence, up to 100,000. Relevant company restrictions apply also to connected people. This this penultimate bullet point there, you can lend up to 100,000. We can lend Benita up to 100,000 for her to buy her main or only residence. She's a director. We can lend her this money. So we lend the money to Benita, and she decides to renovate her home, to buy or improve her main or only residence. She renovates her home and then sells it, presumably for a profit, repays the debt, and she's made herself a private little profit. Then she borrows it again and buys another house, a piece of land, and pays for a house to be built on it. And she sells it, makes a profit, and pays the company back the money. What's this if it's not a loan? What is it if it's not a loan? The law, in my humble opinion, the law is stupid. But I can't say that, because I'm not a member of Parliament. I'm not a judge. Over the page 86. Remedies against naughty directors. If a director has been naughty, if he's overstepped his powers, if he's cheating, if he's got an interest which has not been declared, if he's made a profit out of the fact that he is a director, then that's naughty, that's wrong. It's a wrong being done to the company. And we've got this first one, make them account for a personal gain. Regal, Hastings and Gulliver. Regal is the name of a cinema. The Regal, it used to be a chain of cinemas, the Regal Cinema Group. And Hastings is a town on the south coast of England. And the situation was where the directors of the Regal Cinema, including, just the directors of the Regal Cinema, were given the opportunity to buy another cinema company. I said the directors, the company. was given the opportunity to buy another cinema company. Will you buy our shares? We're prepared to sell them for this. We just want to sell our business, and we're going to offer it to you, the company, first. And the directors sat and discussed it and said, yes, it would be a good idea for our company to buy this other one. How much overall money do we need? And they worked out that they needed, say, £200,000. But the company didn't have £200,000 that it could afford to spend. It only had £80,000. So the company bought 40% of this other company. They spent the 80 and they bought 40%. And then the director said, this is a shame, you know, because I've got some money. Mind you, if the company can't buy the shares, I can. I can buy £20,000 worth myself. And another director said, I've got 30,000 available. I'll buy some shares as well. So the directors personally bought the extra shares that the company couldn't afford. So we now have a company that owns 40%, and this company's directors own the remaining 60%. They bought the company, therefore, then they sold it at a profit, and the directors pocketed their gain. The company made a gain on their 40%, but the directors also made their own profits. And it was found out. Regal Company found out that this is what the directors had done and said, this profit is ours. And the directors said, no, the company couldn't afford it, so we bought it out of our personal cash. And the court said, what? Can the directors keep this profit, or must they pay it back into the company? Must pay back. They must pay it back. It's what's called an abuse of corporate opportunity. An abuse, Madara, of corporate opportunity. That an opportunity is given to the company and the directors take it for themselves. And that's wrong. They're getting a benefit just because they happen to be in a position where they can get that benefit. So they have to pay it back. You can make them indemnify, here's a word for you, indemnify the company against loss caused by their negligence. To indemnify is where the directors say that the company will not lose. If we are negligent, we guarantee that the company will not lose by our negligence. So you can get them to indemnify, to compensate the company if the company makes a loss as a result of the director's negligence. See below, we're getting down here to the bottom two bullet points which explain or illustrate this principle. But I'm going to go back up to number 3 there. They can rescind the contract where a director has a conflict of interest, an undisclosed conflict of interest. Rescind, what's rescission? What's rescission, Sandra? Think Superman. Think of me in my blue suit with my little red pants on. Don't think too long about that. Going up into the sky and making the world go round. And to rescind is go backwards and undo the contract and pretend that the contract never existed. So they can rescind the contract where the director has a conflict. We can ask the courts to declare that a transaction lies beyond the director's powers or beyond the company's ability to enter into. We had a case, didn't we? We had a case where it was claimed by a shareholder that the company was about to enter into a Belgian contract which lay beyond the company's powers. What was the case? Remember? What do you get on the end of a cigarette? Once you lit a cigarette and you start puffing away, what appears at the end of the cigarette? At the far end of the cigarette, not the near end. Ash. Ash. And what do you do with dead people? You bury them. Yes, Ashbury is the name of the company. Ashbury Carriage and Iron Railway Company. Ashbury Railway Company. And a wealthy, very wealthy shareholder. He was a very rich shareholder. He was called Rich, R-I-C-H, Rich with an E on the end. So that was where the contract was beyond ultra vires, was beyond the powers.